When does a rifle become a machine gun? That's the question asked in the Supreme Court case Garland versus Cargill. When the Bureau of Alcohol, Tobacco, Firearms, and Explosives suddenly decided to redefine bump stocks as machine guns, many Americans simply complied. However, when Michael Cargill surrendered his bump stocks to the ATF, he did so under protest, filing suit to challenge the rule under the Administrative Procedures Act. Those of us who enjoy and exercise our right to keep and bear arms owe Mr. Cargill a debt of gratitude. But the fight is not over. Thanks to Mr. Cargill's determination and persistence, the ATF's bump stock rule has been found to have violated U.S. law, meaning we get our bump stocks back. However, it also leaves open the chance for Congress to do what the ATF could not, violate the Second Amendment one more time. So we'll discuss that next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your age and generation be free. I'm glad you could join me today. You know, there were several gun control cases heard by the courts, and, well, this is the first. We hopefully will see some more before they're done with their session. But I wanted to take a look at this one because it's a Second Amendment case. It's not really a Second Amendment case. It's actually about bureaucracies. It's about the agencies simply rewriting federal law and pretending that it's real. So let's take some time and dig into this case, and then when we're done, we'll talk a little bit more about the website. But for now, let's get into Garland versus Cargill. While this case has been watched closely by many in the Second Amendment community, the case isn't actually about the Second Amendment, even though I think it should be. Congress has long restricted access to machine guns, a category of firearms defined by the ability to shoot automatically more than one shot by a single function of the trigger. Now, this is true. Congress has passed a law known as the National Firearms Act that, among other things, restricts access to quote-unquote machine guns. Does Congress have the authority to do so? Contrary to popular belief, the Second Amendment doesn't make distinctions between different types of arms. It simply says, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. The Second Amendment does not limit arms possession to the militia. Neither does it place limits on the types of arms a person can own and carry. It simply states the right of the people to keep and bear arms shall not be infringed. So what is an arm that someone can keep or bear? According to Noah Webster in his 1828 dictionary, arms are weapons of offense or armor for defense and protection of the body. In law, arms are anything which a man takes in his hand in anger to strike or assault another. It would seem this definition, along with the actual language of the Second Amendment, should put to bed most of the gun control arguments. Congress went on to pass the NFA, even though it was criminal for them to do so. In the NFA, Congress made a distinction between machine guns and other types of firearms. The term machine gun means any weapon which shoots, is designed to shoot, or can readily be restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. This distinction between types of firearms is the primary focus of this case. Semi-automatic firearms, which require shooters to re-engage the trigger for every shot, are not machine guns. This case asks whether a bump stock, an accessory for a semi-automatic rifle that allows the shooter to rapidly engage the trigger and therefore achieve a high rate of fire, converts the rifle into a machine gun. Since this case is about bump stocks, it would make sense to specify what one is and how it works. Shooters have devised techniques for firing semi-automatic firearms at rates approaching those of some machine guns. One technique is called bump firing. A shooter who bump fires a rifle uses the firearm's recoil to rapidly manipulate the trigger. The shooter allows the recoil from one shot to push the whole firearm backward. As the rifle slides back and away from the shooter's stationary trigger finger, the trigger is released and reset for the next shot. Simultaneously, the shooter uses his non-trigger hand to maintain forward pressure on the rifle's front grip. The forward pressure counteracts the recoil and causes the firearm, and thus the trigger, to move forward and bump into the shooter's trigger finger. This bump re-engages the trigger and causes another shot to fire, and so on. Although bump firing does not require any additional equipment, there are accessories designed to make the technique easier. A bump stock is one such accessory. So a bump stock is merely an accessory that makes it easier to bump fire a semi-automatic rifle. Normally, a person moves the finger to fire the weapon, but when bump firing, the weapon is allowed to move against the finger. There is more to this case than just bump stocks, though. So what led to this ATF rule to redefine bump stocks as machine guns? For many years, the Bureau of Alcohol, Tobacco, and Firearms took the position that semi-automatic rifles equipped with bump stocks were not machine guns under the statute. On more than 10 separate occasions over several administrations, ATF consistently concluded that rifles equipped with bump stocks cannot automatically fire more than one shot by a single function of the trigger. In April 2017, for example, ATF explained that a rifle equipped with a bump stock does not operate automatically because forward pressure must be applied with the support hand to the forward handguard, and because the shooter slides the rifle forward in the stock to fire each shot, each succeeding shot fires with a single trigger function. It seems to be so often the case we see politics rather than the law at the heart of these regulations. ATF abruptly reversed course in response to a mass shooting in Las Vegas, Nevada. In October 2017, a gunman fired on a crowd attending an outdoor music festival in Las Vegas, killing 58 people and wounding over 500 more. The gunman equipped his weapons with bump stocks, which allowed him to fire hundreds of rounds in a matter of minutes. This tragedy created tremendous political pressure to outlaw bump stocks nationwide. Within days, members of Congress proposed bills to ban bump stocks and other devices designed to accelerate the rate of fire of a semi-automatic rifle. None of these bills became law. Similarly, proposals in the intervening years have also stalled. What we see here is the ATF reversing their earlier position, not because of a change in the law or technology, but because of political pressure. Nothing is mentioned about the fact that anyone can fire hundreds of rounds in a matter of minutes with or without a bump stock. Once again, political pressure was focused on the device rather than the person using it to commit crimes. Even from the beginning of ATF's attempt to rewrite the NFA, they faced problems. While the first wave of bills was pending, ATF began considering whether to reinterpret Section 5845B's definition of machine gun to include bump stocks. It proposed a rule that would amend its regulations to clarify that bump stocks are machine guns. ATF's about-face drew criticism from observers, including those who agree that bump stocks should be banned. Senator Dianne Feinstein, for example, warned that ATF lacks statutory authority to prohibit bump stocks, explaining that the proposed legislation hinged on a dubious analysis and that the gun lobby and manufacturers would have a field day with ATF's reasoning in court. She asserted that legislation is the only way to ban bump stocks. Thankfully, there were several people who took the time, effort, and money to challenge the ATF's power grab. One of those people was Michael Cargill. Michael Cargill surrendered 2 bump stocks to ATF under protest. He then filed suit to challenge the final rule, asserting a claim under the Administrative Procedures Act. As relevant, Cargill alleged that ATF lacked statutory authority to promulgate the final rule because bump stocks are not machine guns as defined by Section 5845B. As you can imagine, since Mr. Cargill's case made it all the way to the Supreme Court, things didn't go his way at first. After a bench trial, the district court entered judgment for ATF. The court concluded that a bump stock fits the statutory definition of machine gun. The Court of Appeals initially affirmed, but later reversed after rehearing en banc. A majority agreed at a minimum that Section 5845B is ambiguous as to whether a semi-automatic rifle equipped with a bump stock fits the statutory definition of a machine gun, and the majority concluded that the rule of leniency required resolving that ambiguity in Cargill's favor. An 8-judge plurality determined that the statutory definition of machine gun unambiguously excludes such weapons. A semi-automatic rifle equipped with a bump stock, the plurality reasoned, fires only one shot each time the trigger acts, and so does not fire more than one shot by a single function of the trigger. The plurality also concluded that a bump stock does not enable a semi-automatic rifle to fire more than one shot automatically because the shooter must maintain manual forward pressure on the barrel. We grant certiorari to address a split in the courts of appeals regarding whether bump stocks meet Section 5845B's definition of machine gun. We see once again in the district court the judges substituting their own preferences for the actual law. The very definition of bump firing involves resetting the trigger, then allowing it to bump into your finger again, meaning that a single trigger function fires one round. Now, Justice Sotomayor wrote a dissent joined by Justices Kagan and Jackson. On October 1st, 2017, a shooter opened fire from a hotel room overlooking an outdoor concert in Las Vegas, Nevada, in what would become the deadliest mass shooting in U.S. history. Within a matter of minutes, using several hundred rounds of ammunition, the shooter killed 58 people and wounded over 500. He did so by affixing bump stocks to commonly available semi-automatic rifles. These simple devices harness a rifle's recoil energy to slide the rifle back and forth and repeatedly bump the shooter's stationary trigger finger, creating a rapid fire. All the shooter has to do is pull the trigger and press the gun forward. The bump stock did the rest. Notice how Justice Sotomayor does not anchor her dissent on the law or the Constitution, but on the emotions generated by a mass murder. It appears quite obvious that these dissenting justices are not interested in determining the controversy based on the law, as their oath requires, but on legislating from the bench. Justice Sotomayor also attempts to mislead in her dissent by misrepresenting how a bump stock operates. She ignores the need to operate the trigger by the rifle going back and forth rather than just a person's finger. Today, the court puts bump stocks back in civilian hands. To do so, it casts aside Congress's definition of machine gun and seizes upon one that is inconsistent with the ordinary meaning of the statutory text and unsupported by context or purpose. When I see a bird that walks like a duck, swims like a duck, and quacks like a duck, I call that bird a duck. A bump stock equipped semi-automatic rifle fires automatically more than one shot without manual reloading by a single function of the trigger. Because I, like Congress, call that a machine gun, I respectfully dissent. First of all, the court is not putting bump stocks back in the hands of the civilians. It is preventing the ATF from illegally removing them. It's not the majority of the court that is casting aside Congress's definition of a machine gun, but the ATF and the dissent. If the dissenting justices see ducks when they look at bump stocks, perhaps they've been watching too many Disney films where ducks talk, wear clothes, and dive into piles of money. 6 of the 9 justices on the court looked at the facts of the case and came to a conclusion. For the foregoing reasons, we affirm the judgment of the Court of Appeals. It is so ordered. Interestingly, although the court made several references to the ATF exceeding its statutory authority in the syllabus of the decision, it makes no direct claim in the opinion itself. Rather, it points to dissenting justices as attempting to rewrite the statute. In any event, Congress could have linked the definition of machine gun to a weapon's rate of fire, as the dissent would prefer, but instead enacted a statute that turns on whether a weapon can fire more than one shot automatically by a single function of the trigger. And it is never our job to rewrite statutory text under the banner of speculation about what Congress might have done. The good news is the bump stock ban is dead, at least for now. Senate Majority Leader Schumer has already announced plans to restore the bump stock ban. While I do not expect Mr. Schumer's plans to work, I also expect others in the anti-Second Amendment community to continue to attempt to violate the Constitution by infringing on the people's right to keep and bear arms. As I stated in the beginning, this case was not about the Second Amendment. Perhaps it should be. It's time to find representatives at all levels of government who recognize our God-given right to defend ourselves from all enemies, foreign or domestic, civilian or government. Only then would those in Congress, the executive branch, and the courts who want to see the American people disarmed be stopped in their tracks. Rather than seeing arms as evil and something to be restrained, we should see them for their benefit and true purpose, as Noah Webster did. Before a standing army can rule, the people must be disarmed, as they are in almost every kingdom in Europe. The supreme power in America cannot enforce unjust laws by the sword because a whole body of the people are armed and constitute a force superior to any bands of regular troops that can be, on any pretense, raised in the United States. A military force at the command of Congress can execute no laws but such as the people perceive to be just and constitutional. For they will possess the power and jealously will instantly inspire the inclination to resist the execution of a law which appears to them unjust and oppressive. So good news. The wicked witch of the bump stock ban is dead. Really dead. Truly dead. But only for now. If Mr. Schumer and others in the anti-gun community have their way, they'll simply oppress our rights via legislation rather than adjudication. It's the nature of the beast. The fight's never truly over. Now here's the question. Does Mr. Schumer represent your ideas? Yes, he represents the state of New York, but are his ideas what you think? Because they don't follow the Constitution. Now, whether that scares him because he knows tyranny can be overthrown by an armed populace, or he's just hoplophobic, has an irrational fear of guns, I don't know, and I truly don't care. See, one of the advantages of a constitutional republic is Mr. Schumer is not the supreme law of the land. Even Congress is not the supreme law of the land. Even federal law is not the supreme law of the land, unless it is made pursuant to the Constitution. It's this knowledge that changes everything. It's this knowledge that allows me to go around and teach what the Constitution actually says, and to point out to attorneys and judges alike that, no, that's not valid. That law doesn't matter. It's void because it violates the Constitution. And those aren't my words. Those are the words of Alexander Hamilton and the Supreme Court. Now, how do I get this? I got this by studying, reading and studying the Constitution, which you can as well. Summer is here, a great opportunity to do some summer reading. Please check out the website, constitutionstudy.com/shop. Buy the Constitution Study. Read it. If you're looking for something to get you started this summer, that is a great place to start. It is my study of the Declaration of Independence and the Constitution, clause by clause in plain conversational English. It is designed so anybody can read it and understand it. Hey, if an 18th century farmer can understand the Constitution, 21st century Americans should as well. So those are your plans, great. Maybe you'll find something else. Maybe you've never read the Constitution. You think it's too hard, or you can't sit down and do it. Well, I have another book there. Read the Constitution in 30 days. It's a 30-day devotional. 2 minutes a day, just 2 minutes a day. In 30 days, you've read the Declaration of Independence and the Constitution. Every clause, every line. It's all there at the Constitution Study. Or maybe you want to check out my radio program, AmericaOutloud.news. Just look for the Constitution Study. Are you tired of companies that take your money and use it to infringe on your rights? Guess what? Patriot Mobile is America's only Christian, conservative, wireless provider. They believe what we believe. They support organizations that protect your constitutionally protected rights, including the Constitution Study. So if you'd like to support us through your cell phone, we'll just go to patriotmobile.com/constitution, find a plan that works for you. Use the code Constitution at checkout, and you'll even get free activation. All these are ways to keep the Constitution Study going so I can keep bringing you this information. Now it's your job. Now it's your turn. Take this information and share it. Share this episode. Share the articles. Share the news about what the Constitution Study is doing. If we want to live free, if we want to fight back against future attempts to infringe on our rights, it's going to be helped to be educated. The way we get educated is by studying. And that's what the Constitution Study is all about. So if you're interested, check it out, give it a try. If you have any questions, just go to constitutionstudy.com/questions and ask. I'll be more than happy to answer any questions I can. You'd also come back and join us here next time for the Constitution Study.